Welcome to the deep dive. Today we're tackling something that's really woven into the fabric of pretty much every interaction where promises are made. Contract interpretation.
That's right.
You shared some really insightful materials, and our goal today is to kind of distill the core principles, the practical takeaways, how these legal agreements are actually understood and enforced.
Absolutely. And I mean, think about it from signing a lease, agreeing to terms of service online, even a simple handshake deal. It all relies on this idea that everyone understands the terms.
Yeah.
So knowing how those terms get interpreted if there's a disagreement down the line, that's incredibly valuable. It's really about making sure those commitments hold up.
Right. Have you ever been in a situation where you thought an agreement meant one thing and the other party thought something completely different?
Oh, definitely. It happens all the time.
That's exactly the puzzle we're going to try and unpack today, what happens when those understandings clash.
And at its heart, the whole process really boils down to one fundamental aim, giving effect to the purpose that was actually laid out in the contract's terms.
Okay, the purpose.
Yeah. Accurate interpretation isn't just like a theoretical exercise. It's the bedrock of making sure the deal you struck is the deal that gets enforced. And it helps resolve any bumps in the road caused by different viewpoints.
Right.
Everything we discussed today, really, it's going to circle back to this central idea, bringing clarity where things are maybe a bit murky, and seeing the agreement in its full context.
Okay, so let's dive in then. Our sources point out that the way courts approach this, it hasn't always been the same, has it? It wasn't always this sort of nuanced exploration.
No, that's correct. Historically, there was definitely a tendency towards a more rigid, maybe step-by-step approach.
Black and white?
Kinda. Courts would often start, and sometimes just end, with the literal plain language of the contract.
Yeah.
Only if there was a really obvious ambiguity would they maybe start looking beyond the words themselves.
But then you had these landmark South African cases, like both Mabatho Transport and Indumini Municipality. They really shook things up, didn't they? Sounds like they were pivotal moments.
Oh, they absolutely were.
Yeah.
The Indumini case especially, that was a major turning point. It involved a dispute about how to read a clause concerning pension fund contributions, I believe.
Okay.
And the key message from the court there was this need to move away from relying too heavily on just the dictionary definition of the words.
Right.
The big shift with Indumini is really recognizing that words aren't islands. Their meaning is, well, it's deeply intertwined with the surrounding text and the actual real-world context of the agreement.
So it wasn't just about grabbing a dictionary anymore.
Not at all, no. The court in Indumini really pushed for a more joined-up way of looking at things. Interpreting a contract became about understanding what the words mean, yes, but always keeping that bigger picture in mind.
Which means?
Well, it means looking at the specific clause within the context of the entire document.
Okay.
And also understanding the situation, what was happening when the contract was actually made.
Our materials lay this out really well. They talk about looking at the actual words used, the context they sit in, the overall purpose of the agreement, and even what the people involved knew at the time. And it sounds like this isn't an a la carte menu anymore. You kind of have to consider all these things together, right?
Exactly. The current way of thinking, which was really cemented by cases like Indumini and both Mabatho, is this integrated, holistic view.
Holistic, yeah.
It's about weaving together all those relevant pieces. Simultaneously, not going through them one by one in some strict order. This was a real departure from the older way of just looking at the surface meaning first and only then digging deeper if things seemed unclear.
Okay, so with this more connected approach in mind, where do you even begin when you're trying to figure out what a contract actually means? Our sources highlight several key starting points. The first one being the purpose of the contract, which makes perfect sense, right? What were the people signing on the dotted line actually trying to achieve?
It really does. It's about looking beyond just the precise wording. To understand the bigger picture, what was the function, the practical aim of this agreement in the real world, especially in a business setting?
What problem were they solving?
Exactly. What problem were they trying to solve? What outcome were they hoping for? That kind of thing.
But our materials also warn against getting too caught up in what someone secretly thought they meant, right? Yeah. It's about the intention as it's expressed in the language of the contract.
That is a really crucial distinction.
Yeah.
While the ultimate goal is to figure out what the parties commonly intended, courts aren't mind readers. They're not going to try and guess unspoken intentions.
Right.
The focus has to be on what that shared intention looks like based on the actual words they chose to put down in the contract.
Which leads us very nicely to the second key element,
Yeah.
the words themselves. That's still the starting point, isn't it?
Oh, absolutely.
Yep.
The language of the agreement is always where you begin. Always. But, as we've sort of touched on, the reality is that words can often have more than one possible meaning.
Hmm.
And that's where the context becomes so crucial. It helps us narrow down which of those possible meanings fits best in this specific situation, this specific agreement.
And that brings us to what our materials call the textual context, looking at how a specific word or phrase fits with the rest of the contract.
Precisely. It's about interpreting a potentially unclear term by looking at all the other clauses, definitions, everything within that same document. One source called it the linguistic treatment, which I thought was quite neat.
Linguistic treatment, yeah.
Words don't exist in a vacuum, right? They
Yeah.
need to be understood in the environment of that particular agreement.
So if one part of the contract clearly spells out what, say, best efforts means, then that definition would probably apply if you see best efforts pop up again later.
Exactly. That's the general idea. And the materials also highlight that if the most obvious, everyday meaning of a word leads to a result that's just, well, nonsensical, or it clashes badly with the rest of the contract,
Okay.
then a court might lean toward a different meaning, one that makes more sense in the overall context of that specific agreement. It's really about making sure all the pieces of the contractual puzzle fit together logically.
Now, things take a bit of a turn when we move beyond just the words on the page to the broader context. And this thing our sources call the parole evidence rule. That sounds like a pretty significant legal concept.
It is, definitely. The broader context involves looking at things outside the four corners of the contract itself. Stuff like the nature and purpose of the deal, the background surrounding when it was created.
Okay.
And the general inclination here, usually, is to favor interpretations that make the contract valid, practical, commercially reasonable. But, and this is important,
There's a limit.
there's a limit.
Yeah.
Judges can't just rewrite the contract to make it seem more sensible based on their own views.
Yeah.
You know, they have to stay true to the words the parties actually used.
Right.
And this is where the parole evidence rule really steps in. It's kind of a balancing act between taking that broader context into account and respecting the written agreement as the final word.
Okay, so in simple terms, what is the parole evidence rule trying to do? What's its main job?
Essentially, its main job is to say that, generally speaking, you can't bring in outside evidence like, say, verbal agreements made beforehand or earlier drafts to contradict or change the terms that are clearly written down in the final signed agreement.
Why?
Well, the idea is to ensure certainty in written contracts, and also to limit disagreements later by focusing everyone on what was actually documented and agreed upon in writing. Reduce litigation, basically.
Makes sense. Our materials break this rule down into two parts, the integration rule and the interpretation rule. Can you maybe walk us through the difference there?
Sure. The integration rule.
Huh.
That's all about figuring out if the written contract is the complete and final expression of the deal between the parties.
The whole deal.
Yeah, is this documented? Think of the integration rule as the court saying, okay, show me the final, complete version of your agreement. We're not going to let you bring in earlier drafts or notes from meetings to contradict what you ultimately signed off on.
Got it.
So if a court decides the contract is fully integrated, then any external evidence that tries to contradict, change, add to, or subtract from those written terms, generally it's not allowed when you're trying to prove what the actual terms are.
Okay, so that's about establishing what the official agreed upon terms were in the first place.
Got it. What about the interpretation rule then?
Right, so the interpretation rule deals more with understanding the meaning of the words that are already in the contract.
Okay.
It's about deciding when and how much you can use external evidence to explain or clarify what those specific words mean. This is where understanding the context, the background, becomes really important. So you can't use outside evidence to say, we actually meant X when we wrote Y.
Generally, no, not if it contradicts Y.
But you might be able to use it to show what Y typically meant in that industry, perhaps.
Exactly, or what X or Y commonly meant at that specific time the contract was signed, or based on their previous dealings. It's about clarifying meaning, not changing the terms.
That makes sense. And our source material points out some situations where that integration rule, that sort of barrier to outside evidence, doesn't fully apply. Exceptions, basically.
That's right. There are definitely exceptions where extrinsic evidence can come in, for example. Maybe to show that the parties never actually intended the written document to be the entire agreement in the first place.
Like what?
Well, maybe there was a condition precedent, something that had to happen before the contract kicked in. Or maybe one of the parties was acting for someone else who wasn't named, an undisclosed principal. Also, if there was a separate oral agreement that was meant to exist alongside the written one, an adjunct agreement evidence about that might be allowed, as long as it doesn't actually clash with the written terms.
And the big ones.
And importantly, of course, in cases involving things like fraud, error, misrepresentation, duress, undue influence, or if something illegal was going on, well, external evidence is often absolutely crucial to uncover the truth there. The rule doesn't protect wrongdoing.
It's interesting that the materials mention a trend, maybe in more recent court decisions,
Yeah.
towards being a bit more open to considering outside evidence, especially when it comes to understanding the context and purpose behind the contract.
Yes, that's a key development to note.
It sounds like the lines between the background facts and the immediate circumstances are becoming a bit less rigid.
That seems to be the direction, yes. Cases like Johannesburg v. Auckland Park Theological Seminary and Capitec Bank Holdings Ltd v. Coral Lagoon Investments, they do suggest a willingness, perhaps a growing willingness, to consider relevant background information to help understand the contract's context and purpose. But,
Always a but.
haha, always, it's really important to remember that this doesn't mean the floodgates are open. You can't just rewrite the contract using outside information. The ultimate interpretation still has to be one that the actual language of the contract can reasonably support. Context informs meaning, it doesn't replace it.
Okay, understood. Now, what if you find yourself in a situation where the parole evidence rule seems to be a hurdle? Let's say you think something was agreed but isn't written down quite right. Our sources touch on a couple of strategies parties might use to try and, well, navigate around it.
Yes, there are ways to approach that. One is to argue for a tacit term.
A tacit term.
Yeah, basically a term that wasn't actually written down, but it's argued it's so obvious or so essential for the agreement to actually work that both parties must have intended it to be there.
Like it goes without saying.
Exactly. The officious bystander test is sometimes used if someone had asked them at the time, oh, but what about X? Would they both have said, oh, of course, that's obvious.
Mm-hmm.
Or maybe it's something commercially necessary for the contract to even make sense. The parole evidence rule has less bite here because you're not trying to contradict written terms. You're arguing for an implied one that fills a gap.
Okay, tacit terms. And the other avenue mentioned is claiming rectification.
Exactly. Rectification is quite different. It's when one party argues that the written contract, as it stands, doesn't actually reflect what both parties truly agreed to because of a mistake.
A typo, maybe.
Could be a typo, could be a clause mistakenly left out, or put in wrong. The argument is,
Yeah.
the written document is wrong, let's fix it. So they ask the court to rectify or correct the written document so it aligns with their genuine, original, common intention. You need pretty strong proof for that, though.
Right, I imagine so. Okay, so we've covered quite a bit. The main goal of interpretation, how the court's approach has evolved towards context, the key elements like purpose, words, context, and this often tricky parole evidence rule.
Hmm.
The last piece of the puzzle our source material brings up is the canons of construction. These sound like, I don't know, set of guidelines, rules of thumb courts can use.
That's a great way to think of them. Yeah, rules of thumb, guidelines. They're essentially non-binding principles that courts can turn to for help when they're interpreting contracts, especially when the language is unclear or ambiguous.
So not mandatory rules.
No, not mandatory rules. There isn't one definitive master list, and a court won't necessarily use all of them or even any of them in a straightforward case. They're tools in the toolbox, really.
Okay.
They're there to help resolve uncertainties and clarify meaning in a way that ideally aligns with what the parties likely intended, or, in the case of laws, the legislator's purpose.
Our materials categorize these into primary, secondary, and tertiary rules. What's the main difference between those levels?
Well, the primary rules are really focused on trying to uncover the meaning that's directly expressed within the contract itself. Things we've already talked about, actually.
Such as?
Like looking at the stated intention of the parties, figuring out the ordinary everyday meaning of the words they used, and looking at how the contract functions as a whole document. Basic interpretation building blocks.
Okay, the fundamentals and the secondary rules.
These often come into play when the primary rules haven't quite cleared things up. They tend to aim for a, let's say, fair and reasonable outcome, often based on principles of good faith or just common sense.
Can you give an example?
Sure. There's one called Iustem Generis, sounds fancy, but it just means of the same kind. So if you have a list like cars, trucks, motorcycles, and other vehicles, that other vehicles probably means other road vehicles, not like airplanes.
Gotcha. Limits the general by the specific.
Exactly. Then there's nosturus associus. A word is known by the company it keeps. The meaning of a word can be understood by looking at the words surrounding it in the sentence or clause.
Okay. Any others?
Yeah, there are guidelines suggesting you give more weight to things specifically typed or handwritten into a contract compared to the standard pre-printed boilerplate text.
Yeah.
Makes sense, right? The custom part usually reflects specific negotiation.
Yeah, that does make sense.
And there's a preference for interpretations that make the contract legally valid and enforceable, rather than invalid or illegal, if the wording reasonably allows for both possibilities. Courts prefer to uphold agreements. And sometimes, if it's still ambiguous, they might lean towards an interpretation that achieves a fair and equitable result.
Okay, those make sense. Then we get to the tertiary rules, the ones used apparently as a last resort. These sound particularly interesting.
They are interesting, yeah. These are the rules a court might turn to when they've tried the other approaches, and they still can't definitively figure out the expressed intention of the parties from the document.
And the main one here is...
The big one is contra preferentum. It means that if there's an ambiguous term in a contract, it will generally be interpreted against the party who drafted or supplied the contract.
Against the drafter. Why is that?
Well, the thinking is that the party who wrote it had the chance to be clear. They controlled the language. So if they created ambiguity, they should bear the consequences, not the person who just had to sign it. It encourages clearer drafting.
So if you're ever presented with a contract someone else wrote and a part is unclear,
That ambiguity could actually work in your favor if it gets to a dispute. It's a powerful tool for the non-drafting party.
that makes perfect sense. It definitely incentivizes clarity. The other tertiary rule mentioned is quad minimum. Sounds Latin again.
Yes, quad minimum. This one comes into play mainly when you're interpreting ambiguous obligations or debts. It suggests interpreting them in the way that imposes the least burden on the person who owes the obligation or the debt.
Least burden on the debtor.
Essentially, yeah. The underlying idea is that you shouldn't assume someone intended to take on a bigger responsibility or pay more than they clearly agreed to. If it's unclear how much they owe, interpret it narrowly.
Okay. And sort of the worst case scenario, what happens if you go through all these rules, primary, secondary, tertiary, and there's still genuine, irresolvable ambiguity in a key part of the contract?
Well, unfortunately, if all the tools of interpretation have been used and the contract or a crucial part of it remains fundamentally unclear, the final result could be that the contract is deemed void for vagueness.
Meaning,
A court might just say, we can't figure out what this means, so we can't enforce it. It effectively falls apart, which is why clarity in drafting is so important from the start. Unless, maybe, you secretly want it to be unenforceable, but that's a risky game.
definitely sounds risky. Finally, our source briefly touches on a specific category of clauses: disclaimers, indemnities, and exemption clauses. You know, the ones trying to limit or exclude liability.
Yes, the small print sometimes.
Exactly. It says, if there's any ambiguity in these clauses, they're also generally interpreted contra preferentum against the party who put them in.
That's absolutely right, and it's a really important application of that principle. Because these clauses can significantly shift risk and take away rights someone would normally have, courts tend to scrutinize them very closely.
So they construe them narrowly.
Very narrowly, yes. Any lack of clarity, any ambiguity will almost always be held against the party who is trying to rely on that clause to avoid liability. It provides more protection to the party whose rights might be limited.
Okay, wow. We have covered a huge amount of ground today, from the basic aim of figuring out what a contract means, all the way through the evolution towards context, the parole evidence rule with its ins and outs, and those canons of construction.
We certainly have.
The real takeaway for me seems to be that it's all about trying to understand the original purpose and intent behind the words, but always, always staying grounded in the actual language that was used on the page.
Precisely.
Yeah.
You've nailed it. And having an understanding of these principles, even at this level, gives you, our listener, a much sharper lens to look through when you encounter any agreement.
Yeah.
Whether it's navigating business deals in your professional life or just understanding the terms and conditions you click agree on in your personal life, knowing how these documents are likely to be interpreted gives you much greater clarity and insight. You're definitely better equipped now to see how legal understandings are built from these documents we all create and rely on.
It really does make you think, though, doesn't it? With all these layers and nuances we've discussed, how well does the average person truly grasp the contracts they encounter every single day? Clicking agree online, signing rental agreements?
Mm, that's a big question.
And what are the broader implications of that potential gap in understanding? That's definitely something worth pondering, I think, the next time you're faced with pages of legal text. Thanks for taking this deep dive with us today.